right.
Hello class, my name is Taylor, and today I'll be talking about cannabis and firearms. 28 states now recognize the use of medical marijuana, and 33 states recognize the recreational use. According to Statistica in 2018, there are 916,000 medical marijuana users in California and over 2.1 million users across the U.S. That is over 2.1 million citizens who have waived their right to their Second Amendment. Under the Brady Act of 1933, background requirements were added to protect people from legally buying a firearm. However, the requirements of the Brady Act discriminates against cannabis users from purchasing a firearm. The federal government must revise its outdated laws on this topic to protect the rights of all citizens, keep laws consistent from federal to state level, and resolve the stigma of relation between gun violence and cannabis use. The legislation that set the precedent for modern-day laws is outdated and vague. Therefore, it does not equally protect the rights of all citizens. According to the National Criminal History Improvement Program, in 1933, the Brady Act prohibited the sale of firearms to any individual who, ellipses, is an unlawful user of or addicted to any controlled substance. This legislation prevents millions from their Second Amendment rights. The argument stems from the fact that cannabis is becoming illegal across the country and should therefore not be considered a controlled substance. After all, there was a time when alcohol was considered a prohibited substance. Imagine the public outroar that would have occurred if alcohol users were prohibited from owning firearms after the prohibition had ended. Although this legislation is effective in other regards, such that it prohibits felons and fugitives and the mentally ill from purchasing firearms, it impedes on the rights of some citizens. The government has amended this legislation, but in all the wrong ways. The Brady campaign in 2017 stated that Attorney General Jeff Sessions had issued a clarification of the definition fugitive from justice, asserting that fugitives shall only be blocked by background checks if they cross state lines to purchase their firearms. And this removed 500,000 names from the prohibited list. In essence, our government is willing to grant fugitives gun rights before it grants those rights to cannabis users. There must be sound federal policy that recognizes and corresponds to modern state laws to equally protect all citizens. Marijuana laws are confusing, abstract, and numerous, making it difficult to have a comprehensive knowledge of the rules in different areas. Marijuana is illegal under federal law, even in states that have legalized it. However, local city ordinances and laws truly decide who and how marijuana is consumed. Each county or city has a varying set of laws regarding cannabis, and it is important to know these laws before you engage in any cannabis-related activities. For example, San Luis Obispo passed Prop 64, the legalization of marijuana, in 2017 by a staggering 65%. And these are the laws of what you can and can't do in Slum. It's very specific. You can grow indoors, but you can't grow outdoors. So you must know the rules where you are. People are attempting to reform this legislation that prevents cannabis users access from firearms. However, in one court case, it completely backfired. In 2010, a lawsuit that went all the way to the Ninth Circuit Court of Appeals, it was upheld that the ban of gun sales to state legal medical marijuana patients does not violate the Second Amendment. Further, after this decision, the Bureau of Alcohol, Tobacco, Firearms and Explosives actually added a Form 4473 and amended the question to state, are you an unlawful user of marijuana? This directly excludes cannabis users from purchasing a firearm. The suit was intended to create a separation between cannabis and other controlled substances to show that cannabis can be treated in legal regards more like alcohol and tobacco, not meth. And you'd be surprised to find out that our government actually classifies weed as more dangerous than meth. But later on that. However, despite the intended effect of the suit, the reality was that specific questions were directed at cannabis users after. Furthermore, background checks that were conducted by FBI rejected a greater amount of applications based off drug involvement, 4%, versus state and local checking agencies, which is 1%, stated L. Gifford in background checks for firearms in 1999. It's clear that federal law is stricter towards cannabis than state laws are. However, there will come a day when perhaps all 50 states have legalized that the federal government will readjust its inconsistencies in its legislation. Laws must be simpler and consistent from state to federal level. The relation between drug use and crime is far from complete. This is because there is little research done on individual drug consumption and individual crime commission. However, a recent study titled Probing the Link Between Drugs and Crime by Bernard Groper correlates harder drugs and crime, indicating that intensive narcotics abusers are heavily involved in crime, much of it violent. And furthermore, the study explained that at different levels of abuse of such drugs as heroin, cocaine, and opiates are directly related to criminality at the individual level. And individuals who abuse such drugs in different degrees will have different corresponding levels in crime. Although there is little research concluded individually on cannabis and crime, there is proof that harder drugs lead to an increase in crime. And at this point, I would like to call attention to the government-regulated schedule of drugs. According to the California Department of Justice, marijuana is ranked alongside heroin, and LSD is a Schedule I drug. These drugs are considered by the DEA to have no medical value and are highly prone to abuse. However, cocaine and meth are classified as Schedule II, because according to the DEA, although that they have high prone abuse rates, they have medical value, which is confusing because the research that I read was the exact opposite. With current research, the federal government can reassess the individual consequences from different drugs and evaluate its legislation from there. Because I don't know about you, but I'd like to believe marijuana is a little less damaging to a person's health than meth, and should be treated that way in law. Times are changing in politics, and more discussion on cannabis is presented in lawmaking settings. Last June, President Trump said he'd probably support the STATES Act, which would exempt legal state cannabis businesses from the Controlled Substances Act, eliminating the fear of federal persecution as well as taxes. This act would remove restrictions placed on cannabis users while still regulating the usages of more dangerous substances. And although we all have at least some issues with Trump, I think this one wasn't half bad. The States Act will grant the right of arms to 2.1 million people who perhaps didn't even know that they had waived their right. It is also to bring consistency and fluidity to legislation at state and federal levels. And finally, it will be one of the first legislations that confirms there truly is a difference between weed and meth. Thank you.